Leader of the Opposition.
Thank you, Madam Deputy President. I lead for the opposition in debate on the Bail Amendment Bill 2015 and the Terrorism Police Powers Amendment Bill 2015, which are being debated cognately. The opposition does not oppose these bills. I turn first to the Terrorism Police Powers Amendment Bill, the object of which is twofold. Firstly, to remove the authority of the New South Wales Crime Commission and staff to exercise powers relating to covert counterterrorism search warrants. This follows a request of the Crime Commission that has been in the public domain for some time. According, the provision can only be regarded as sensible. If the power is not used and the agency does not want it, then taking it off the statute books is what should happen. The other object is to extend the current regime of preventative detention orders. That is, that the scheme that allows a detention without charge has recently been the subject of a proposal by this state government, opposed by the federal government, to increase the maximum detention period to 28 days. The government forgot to mention the publicity that surrounded that discussion, that the preventative detention scheme was actually scheduled to collapse and disappear on the 16th of December this year. The government forgot to mention that it was the subject of a sunset provision. The government has known for over 3 years that this was the case, but left it until late in this year before acting, and in an extraordinary display of incompetence and sloppiness. The provisions of the bill extend the operation of the scheme for a further 3 years following the expiry of the current sunset period. As I indicated, Labor will not oppose the bill. The challenge of terrorist attacks has not decreased since the scheme was first introduced. Despite scepticism about the scheme by the Independent National Security Legislation Monitor and the State Ombudsman, the Lint Cafe siege and the recent Parramatta attack mean that the scheme must continue. The scheme is to be continued for a further 3 years, which is appropriate and supported by the opposition. Turning now to the Bail Amendment Bill, the object is to amend the Principal Act, the Bail Act 2013, following a number of reports and reviews. Not all the recommendations in those reports and reviews are being adopted, however the bulk of them appear to have been. They concern the final report of the review of the Bail Act 2013 by now His Honour Judge Hatzistikos, which I'll call the Bail Act Final Review, a report by the Sentencing Council on bail additional show cause offences and the Martin Place siege, Joint Commonwealth New South Wales Review. This is the latest stab by this government, the bail laws. Members of the government have changed the bail laws more frequently in a short space of time than other governments. In 2010, everyone agreed that the bail laws had become overly complex, largely because of bipartisan tinkering and fiddling with the 1978 legislation. The government elected in 2011 referred the issue to the Law Reform Commission and promised root and branch reform. The Commission recommended substantial changes. However, the government elected to not proceed with the Law Reform Commission proposal and proposed instead a model put forward by police based on the concept of acceptable risk. That was enshrined in the 2013 bill, which commenced in May 2014. That was then the subject of further changes proposed by the Hatzistikos Review, involving specifically a show cause provision in relation to more serious offences. This commenced in January 2015. This has been a chaotic and haphazard approach by a government that doesn't seem to really know what it's doing. In her second reading speech, the Attorney-General in the other place said that the tough new laws and the show cause provisions were working well. There should in fact be several caveats placed on this. The show cause system has not all been smooth sailing. For example, the Sentencing Council noted, and I quote, "There has also been some uncertainty regarding the operation of the show cause test itself," unquote. The Sentencing Council developed that proposition in more detail in the report and canvassed various alternative approaches. Likewise, commencing at page 23, the final report of the Bail Act Review set out the various competing approaches that may be pursued. This does not assist certainty, let alone clarity. The issues of a one-step or a two-step approach by a bail determining authority may well be a fertile source of disagreement and potential confusion. But that is not the end of the Sentencing Council's concerns. It states, and I quote, "We have a number of concerns about the breadth of the existing on-bail show cause category," unquote. The Council will continue to review it and will report subsequently. It deals in detail with this in Chapter 8 of the Council's report. There is another problem with the Attorney's comments, especially in relation to her claim that the legislation is so much tougher and by implication that so many more people are now being denied bail. Regrettably for her, those claims about the 2014 legislation fly in the face of the Independent Observer. In the issues paper number 106 dated August 2015, the Bureau of Crime Statistics and Research, BOXAR, said this, and I quote, "The New South Wales Bail Act 2013 and the show cause amendments subsequently made to it have not increased the police or court bail refusal rate above the level that prevailed in the 2 years prior to the introduction of the Act," unquote. The same report states, and I quote further, the police bail refusal rate is now around 2 percentage points lower than it was in 2012 and 2013. The court bail refusal rate has returned to the level that prevailed in 2012 and 2013, unquote. The conclusion of the report states, and I quote again, the New South Wales Bail Act 2013, as amended, does not appear at this stage to have increased the percentage of persons refused bail or the size of the remand population, unquote. This is also the position put in the Hatzistikos final report of paragraphs 85 and 86. The bail refusal rate is broadly the same for previous years. There are more people on remand, but as Boxar points out, that is because more people have been arrested for more serious offences. While absolute numbers have gone up, that has nothing to do with the legislation. Significant numbers of accused certainly are denied bail in the show cause category, but as Boxar points out, that will be the case under any similar legislation because they involve more serious offences. The Hatzistikos review points out that rates seem to have been the same for show cause offences before and after the commencement of the 2014 amendments. This statistical material makes a complete mockery of the government's claims about bail laws. In the debate on the 2014 legislation, the Labor opposition said that we did not think the government had any idea what it was doing about bail. Nothing has occurred since to change our mind. If anything, the evidence keeps mounting in favour of the proposition. The government keeps making amendments, poking at, prodding at the legislation, doing to the Act precisely what successive governments did to the 1978 Act. Similar results will probably eventuate. Turning to the proposals in the bill, the Sentencing Council report dated May 2015 made one recommendation for amendment of the Bail Act. That was to expand the definition of serious personal violence so that it includes appropriate offences committed in other jurisdiction. This recommendation is included in the bill. That gap did not exist in the pre-2013 legislation. It was contained in the amended 1978 Act, having been introduced by the Labor government in 2003. For some reason, the current government did not follow that precedent. Its inclusion in the 2003 amendment was uncontroversial, and its inclusion in this bill is entirely appropriate. The only issue is why it was left out to begin with. Part of the bill also reflects the recommendations of the final report of the Hatzistikos review of the Bail Act. The final report is dated June 2015. The government, in its usual leisurely way, took until August to announce support for the recommendations in that report and took until now to introduce the legislation. Given that timescale, it's hard to take seriously the government's rhetoric that this is a crucial piece of legislation to ensure community safety. The final report followed an interim review report released on 5 August 2014. The final review proposed to focus on the application of the Bail Act 2013, particularly in light of the Bail Amendment Act 2014. That in turn followed the recommendations of the interim report that came into effect on 28 January 2015. Schedule 1 of the bill legislates a number of the recommendations. The Act is amended to enable a determination of bail pending sentence, taking into account when an accused is found guilty and a custodial sentence is probable. That was raised by the Director of Public Prosecutions, who pointed to the precedent of the 1978 Act, which had a different approach to the 2013 Act. The report recommends, and this bill legislates, the 1978 position rather than the 2013 legislation. Schedule 1 Item 2 reflects Recommendation 1 of the final review. Schedule 1 Item 4 reflects Recommendation 3. Schedule 1 Item 6 reflects Recommendation 2. Schedule 1 Item 7 is based on Recommendation 14. Schedule 1 Item 9 is based on Recommendation 15. And Schedule 1 Item 12 is based on Recommendation 7 of the final report. Recommendation 7, which is legislated in this bill, removes Section 78 of the Act, which deals essentially with breaches of bail. Relevantly, that section provides that a bail authority may revoke or refuse bail only if satisfied that the person has failed or is about to fail to comply with a bail acknowledgement or condition, and if, having considered all possible alternatives to the decision to refuse bail is justified. The report is focused on the last part of that formulation, which is to be found in Section 78, subsection 2b, which was not in the 1978 Act, nor was it recommended by the Law Reform Commission. The report notes that each breach must be viewed in context. On the one hand, some breaches will change the risk profile. On the other hand, some will be merely technical. The report argues that for that reason, this provision is a distraction or it is an elevation of the accused's interest such that it distorts the statutory function of the bail determining authority. The repeal of the section seems to leave the position at this point that where bail is breached, revocation should merely be considered on the facts of the case. Put in those terms, the proposal does not seem to have any particular difficulty attached to it. However, I flag ongoing interest in the consequences of that decision to see whether there's anything more than an entirely natural and rational consequence of that. I turn now to discuss the terrorism components of the bail legislation. That genesis of terrorism provisions in the bill are to be found in the Joint Commonwealth New South Wales review of the Martin Place siege. The report of the review was released in January this year. It has taken 9 more months for this leisurely process to result in this legislation. The proposals in the bill are not of great import. either are not of great import or this government has been culpably lazy. They are the obvious alternative possibilities resulting from the delay. The interest of the review and bail related to Man Monis, his interactions with the legal system and bail decisions relating to him. I note in passing that subsequently there was considerable focus on similar issues by the coronial inquest. The joint review makes these useful comments, and I quote, "Not all accused persons are kept in custody until their trial is concluded. Bail enables a person who is in custody charged with a criminal offence to be released from custody on the condition that he or she appears in court and complies with any specified conditions. Bail laws attempt to strike a balance between the liberty of an accused person who is entitled to the presumption of innocence unless and until convicted for the offence of which he or she has been charged, and ensuring that the accused person will attend court, not interview prosecution witnesses and not commit any further offences," unquote. The relevant section of the review at page 43 concerning Monis and bail stated, and I quote, "The recent amendments to the Bail Act 2013, which are now in force, require a bail authority to consider any criminal associations in assessing if an accused is an unacceptable risk. This new factor recognises that an accused's link to crime networks can have a direct impact on their level of risk to the community if released on bail. The review found there is an opportunity to consider strengthening the bail laws to require a bail authority to take into account an accused person's link with terrorist organisations or violent extremism, even though the review also found that Monis did not demonstrate a desire or intent to commit politically motivated violence prior to the siege," unquote. Interestingly, the review also stated, and I quote, "A proposal will be developed jointly by the Department of Premier and Cabinet, the Department of Justice and the New South Wales Police Force, with a view to submitting it for the New South Wales Government's consideration at the same time as consideration is given to the final report of the Hatzistikos review of bail laws. This proposal will be developed jointly by the Department of Premier and Cabinet, the Department of Justice and the New South Wales Police Force, with a view to submitting it for the New South Wales Government's consideration in mid-April 2015, unquote. The comments led to recommendation 5 of the joint review. A number of points emerged from this in relation to the bill now before the House. Firstly, the existing law substantially covers the ground already. If an accused's links to crime networks is already a factor to be considered, that must already include an accused person's links with terrorist organisations and violent extremists. They are obviously a criminal network. The recommendation makes explicit something that is already there. The review's recommendations were adopted by the state government in February. Interestingly, it also refers to the proposal going to the New South Wales Government in mid-April. 6 months after that, this legislation is introduced to the other place and now this House. Comments have already been made about the delay surrounding the process. The next bit of action by the government was a media release quoting the Premier and the Deputy Premier. Their rhetoric said they were introducing tough additional protections. They were sending a very strong message. This bill is the result. Those comments were made in a media release in August. But the rhetoric of the Premier and Deputy Premier is completely unjustifiable in light of what the government has belatedly introduced. It was a shameless beat-up of quite moderate measures that at best are making explicit something already present in the law. The changes provide that bail will be refused unless there are exceptional circumstances if someone has been charged with an offence carrying a custodial sentence and is a person in relation to whom a terrorist control order has been made, is on bail for or has been convicted of a Commonwealth terrorism offence, including being a foreign fighter, or is on bail charged with being a member of a terrorist organisation under Section 310J of the Crimes Act. There are several things to note about these provisions. The first is the reversion to the phrase exceptional circumstances. That, of course, was at the centre of the pre-2013 bail laws that this government had said were not adequate and needed to be altered. That is, it has returned to the formulations of the previous bail laws it attacked so comprehensively. In its rush to deliver clever soundbites, it has adopted all the things it used to criticise. The pre-2013 bail provisions now have centre stage in the 2015 legislation. Secondly, the suggestion that this represents a major change to the law is complete nonsense. The chances of people in these categories getting bail now is pretty much zero, unless, of course, there are exceptional circumstances. Thirdly, it is worth adopting an evidence-based approach to these provisions and actually seeing how many people will be affected. Following the August media release, the Shadow Attorney-General in the other place asked the Parliamentary Research Service to carry out some work as to the incidents that would bring alleged offenders within the provisions of this legislation. It provided him with a report dated September 7, so it's a little under a couple of months old. Starting with the last provision, Section 310J of the Crimes Act, I am advised, and I quote, "Statistics from the Judicial Commission which relate to the finalisation of principal offences show that in the local court between April 2011 to March 2015, there were no convictions for offences against 310J of the Crimes Act 1900. In the District and Supreme Courts between January 2008 to December 2014, there were no convictions for offences against Section 310J of the Crimes Act 1900. Nor have there been convictions in New South Wales against the counterpart Commonwealth offence of a membership of a terrorist organisation in Section 102.3 of the Criminal Code Act 1995 Commonwealth. Turning to foreign fighters, the relevant provisions are Sections 119.1 and 119.2 of the Criminal Code 1995, which were inserted into the Criminal Code by the Counterterrorism Legislation Amendment Foreign Fighters Act 2014 on 1 December 2014. The Judicial Commission's statistics for New South Wales, which are presently current to December 2014, do not show any finalised offences against Sections 119.1 and 119.2. The Commonwealth Sentencing Database statistics, which are current to 30 June 2015, also do not record any finalised convictions against these offences. The Counter-Terrorism Legislation Amendment Foreign Recruitment Act 2014 replaced the Crimes, Foreign Incursions and Recruitment Act 1978. According to the Commonwealth Sentencing Database, between 1 July 2010 to 30 June 2015, there were no convictions in New South Wales for an offence against the Crimes, Foreign Incursions and Recruitment Act 1978, Commonwealth, unquote. There are also interesting figures in relation to the number of control orders, and I quote, "The Attorney-General, Commonwealth, is required under Section 104.29 of the Criminal Code Act 1985 to report on terrorism control orders. A series of annual reports on control orders has been published online since 2008-9, with the exception of 2010-11. According to the figures in those annual reports, between 2008-9 and 2013-14, excluding 10-11, no control orders were made in New South Wales or elsewhere in Australia. The Commonwealth Attorney-General's Department has advised that, since the last annual report, 5 control orders have been made across Australia," unquote. As I indicated earlier, the report received was dated September and cannot record incidents subsequent to that. The Judicial Commission statistics reveal 10 cases of people or persons charged with Commonwealth terrorism offences between 2008 and December 2014. The Commonwealth Director of Public Prosecutions has confirmed that in New South Wales 8 people were charged under the terrorism provisions of the Criminal Code 1995 and the Crimes, Foreign Incursions and Recruitment Act. None of this argues against the bill, however it does suggest that the government's rhetoric should be more careful. Whilst there may be a sensible theoretical argument to include a range of offences within the provisions of this bill, it seems inappropriate to say that great changes are being made when you are including offences with which no one has ever been charged. Slightly less histrionics and more considered rhetoric would be a much more honest approach in dealing with the community on critical issues such as this. The legislation also introduces a number of factors that must be taken into account when a bail authority is applying the unacceptable risk test for bail. These are an accused person's linked to terrorist organisations, an accused person's statements or actions advocating supports for terrorist activities and or violent extremisms, and or accused persons or groups who advocate support for terrorist activities and or violent extremism. Section 18 of the Bail Act currently provides a lengthy list of matters that should be considered as part of the assessment. These include, among other things, the accused person's background, including criminal history, circumstances and community ties, whether the accused has a history of violence or the accused person has any criminal associations, and the likely effect of the offence on any victim and on the community generally. It is hard to see how these newly added factors are beyond the matters already to be assessed. No cogent argument has been advanced by the government to that effect. It simply makes explicit things that are already included in the legislation. There is no harm in adding these provisions. There is merely an issue as to their absolute necessity, given what is already in law. Having said that, it does not do any harm, and the opposition does not oppose these bills.